We have Sarah.
Hello.
Hello, Sarah.
Hello.
Good morning.
Okay. I'm trying to figure out, I've honestly never Zoomed on my phone before, if you can believe it. So am I on video and audio?
You are.
Okay. Oh, awesome. Okay. I did something right. Fantastic.
It seems to be working great.
Great.
Okay, welcome to the July meeting of the Commission on Governmental Ethics and Election Practices. And we're going to get right into it. Starting with agenda item 1, a ratification of the minutes of the May 28th, 2025 meeting. Do I have a motion?
I'll move acceptance as presented.
Is there a second? Is there discussion?
Just one brief correction on page 2, bottom paragraph. There's a spelling error. Third line up, insteady instead of instead.
Oh.
Maybe a word I didn't learn in school.
Well, you just proved that, you know, to our knowledge, you at least read page 2 of the.
I'll move that we amend the minutes to remove the Y on insteady. Second. Is there a discussion? I'll call for a vote. We'll do it by roll call since we've got Commissioner Leclerc remote. Commissioner Leclerc?
Yes.
Commissioner Marvel?
Yes.
Commissioner Hastings?
Yes.
And I'll vote yes too. And we have a motion to ratify the minutes. Is there more discussion? So I'll call for a vote. Commissioner Leclerc?
Yes.
Commissioner Marvel?
Yes.
Commissioner Hastings?
Yes.
I'll vote yes as well. Okay, so moving on for agenda item 2. This is a request for investigation of the school construction referendum in Cape Elizabeth. Do we have people joining us? Okay. Ms. Lynch, I see you.
And I see you.
Terrific. It's working.
It's working from Madawaska Lake.
Oh, very lovely.
Mr. Benoit did not call in.
Okay,
I was expecting him, but he's not on.
so Mr. Benoit is not joining us.
Mr. Benoit is on a previously scheduled vacation, so he's left everything to me.
Good for him. All right, so what we'll do is we'll refer to Jonathan, Mr. Wayne, and then we'll get started.
This is a complaint filed by Marianne Lynch and Robert Benoit about 2 referenda in the municipality of Cape Elizabeth relating to school construction. And the complaint alleges that the municipal school department spent more than $5,000 for the purpose of influencing these 2 referenda, and therefore that the school department or the superintendent ought to have registered with our office as a ballot question committee and filed financial reports detailing how much they spent for the purpose of promoting these referenda. And the school board responded that they were not trying to influence the referenda, that they are under a duty to engage members of the public and get them involved in the process and expressing opinions about the issues and attending public meetings and so forth, and also to educate the voters on the issue. And that's why they spent money on ads in the local newspaper before the 2024 referendum and the 2025 referendum. And the commission met at your last meeting and discussed this issue and decided to hold off making a determination on the complaint in order to receive legal memos on the issue of whether a municipal entity is covered by this ballot question committee reporting statute. So since your last meeting, we received a memo from Ms. Lynch and Mr. Benoit. We received a memo from Adrienne Bounce, who's the attorney for the school department. She's here today. And you received a memo from your legal counsel, Jonathan Bolton. And that's where we're at as of today.
And then we received a response memo from Ms. Lynch and Mr. Benoit.
That's correct. Thank you. I should mention that. And it was in email format.
Terrific.
Yeah.
Okay, so our procedural status right now is that we have a motion on the table to take no further action on the complaint. We heard all the evidence at the last meeting. Both sides of the issue had a chance to discuss it with us and make presentations. And we closed the evidence. We opened it up for legal argument. And as Mr. Wayne said, we received legal argument from the complainants and the respondents and from our attorney, Mr. Bull. And we received a response memo from Ms. Benoit and or Ms. Lynch and Mr. Benoit. So I think we have a motion on the table and it's open for discussion.
Questions as this procedure goes?
Yes,
I
please.
don't know I don't have an answer to this question.
Yes, please.
Since folks have come here today, and Ms. Lynch is connected, should we allow any further statements from them as part of discussion?
I think if you need it, or if you would appreciate hearing legal argument from anybody.
Anyone who knows me knows that I would just as soon not get into too much legal argument, but I thought that if folks had followed up what they've submitted with attendance this morning, if there's anything they might wish to add relevant to this that they have not already said in response to submissions, I would welcome time for them to do that.
I'd be happy to entertain that.
Thank you.
Ms. Lynch, would you like to add anything in the form of legal argument to your submissions?
Thank you very, very much. I appreciate the opportunity, and I know you've spent a lot of time on it and have about 200 pages in your packet. So I promise you I will keep my comments to 2 minutes or less. I would just point out to you that the commission's own counsel in the filing that they made last week concluded that the term person could reasonably be interpreted to include a municipal entity. I'd also point out to you that the definition of campaign means any course of action to influence a municipal election. Any course of action. In order to get around the plain meaning of the statute and the definitions of person and campaign, the staff and the school board's attorney have suggested that there's a public policy that favors excluding the school department from regulation because they are providing information to the public. You know, I think it's fair to say we all agree on the purpose of the law that you are administering. It's to provide transparency, accountability, and fairness in order to promote the integrity of elections. So I think the question before you today is really, should you have a lesser standard for those who are responsible for spending public money? A double standard when you hold private individuals to transparency and accountability, but not require the same of public officials who are, or public employees in this case, who are spending thousands of dollars. I suggest to you that this commission got it right in 2009 in rejecting a double standard. And I would ask you to uphold your precedent. And again, I thank you very, very much for all of the time that you've spent on this issue.
Thank you, Ms. Lynch. Would the respondents like to present anything?
Good morning.
Could you introduce yourself,
Adrian
please?
Fouts. I'm counsel for the Cape Elizabeth School Department.
Terrific, thank you.
And good morning, nice to see you again. I'm Chris Record, Superintendent of Cape Elizabeth.
Good to see you both.
So just very briefly, don't want to reprise what's already stated in the letter that we submitted, and thank you for the opportunity to comment. But I think two primary points that I'd like to make in response to Ms. Lynch's comments. There is a very important binding legal principle here, and that is the main state law around how statutes should be interpreted when you're looking at whether or not they apply to governmental entities. So there is not a presumption that a statute applies to a governmental entity. It's actually the inverse. And the rule of law is that the statute should only be interpreted to apply to a governmental entity if it explicitly states that it applies to such an entity. I think it's clear that that is not the case here, or we wouldn't be engaged in this exercise. So we would encourage you to follow that stated legal principle that a statute should not be interpreted to apply to a governmental entity unless it explicitly states that it is. And in this case, the department is a school administrative unit, which is an agent of the state. It is a statutorily created governmental entity, public entity, and that principle should extend in this case. On the public policy argument, we agree with the position of the commission staff and Mr. Bolton that in this case, the public policy considerations really also favor an interpretation that person under the statute does not extend to the school department. And that's not a double standard. It's not a lesser standard. It's that simply the considerations are different. The public policy purposes behind, as you all know, and I think I agree with Ms. Lynch, I think we all agree on this, behind the campaign finance laws are, transparency, being able to understand who a message is attributable to, what their motivations may be, financial transparency. Those interests are already met. The school department has obligations to the public, statutory obligations that it meets by providing information to the public. It is identifying itself as the source of that information, and it also has other disclosure requirements that individual citizens and private citizens and private corporations do not have, such as financial disclosure obligations, and also, of course, being subject to freedom of access laws. So we're happy to answer any questions, but really those are the two primary points that I wanted to make, that there is this statutory interpretation principle that should govern here, and that the public policy considerations are really different in the context of a governmental entity like a school administrative unit. Happy to answer any questions or for Mr. Record to add anything if you'd like.
Thank you. Mr. Record, do you want to add anything?
No, I'm all set.
Okay, great. Does anybody have any questions?
No questions.
Okay, thank you very much.
Thank you so much.
Thank you.
So we'll proceed into discussion.
Then I'd like to ask Mr. Bolton if after a lot of work, you had anything either new to comment on or rank responses to anything we may have heard this morning.
I think the only thing I'd say is, the one thing my memo didn't focus very much on is public policy. And I think there are arguments in both directions on public policy. And I think it's certainly something that you all can consider. But I also think it's something that me as your legal counsel that I don't necessarily have any special insight into the public policy implications any more than you all would. So I guess I don't have a strong view about that one way or the other. I think arguments can be made either way.
Thank you. And that's appropriate. Commissioner Hastings.
Well, I want to thank on both sides for very excellent presentations and memorandums. I also want to thank Mr. Bolton for an excellent job that you have done. You put a lot of time into this and I appreciate it. When we asked you to put something in writing, you really did. And I thought it was well, I am persuaded by your arguments. I understand it's a very close call as to whether a governmental entity could be a person, but I am persuaded by the argument that the general law in Maine is that unless a governmental entity is specifically made subject to a requirement, that it is not. This is not the state. I think if we were dealing with the state of Maine here, I don't think we'd be even having this argument. But because we're talking now about subunits, school units or towns, it's still persuasive to me that, under the status of the law now, that we should find that a governmental unit is not a person under our statute. And from public policy point of view, in the case of where a governmental entity is really just talking about its own project, something it's put forward, well, it's just totally understandable that it is probably speaking about that in a positive way. But I think it has and I understand that it has an obligation probably to do so. I'm a little more troubled about like the South Portland case where the government was really taking a position on a referendum, a statewide referendum. But I think that would probably be something for the legislature to take up if it wanted to draw a distinction between the two. But so at this point, I would agree that we should essentially take a different position than they took in 2009, I guess, on the South Portland case, and find that a governmental unit is not a person, and accordingly that is not these acts were not subject to our law, and that we should therefore not proceed with any investigation.
Thank you.
And with that, I will move, just so we'll have something on the table, that the commission take no further action on the.
That motion is already on.
What's on it? Okay.
Yeah. Thank you. Anybody else, other commissioners?
Briefly.
Yes, please.
So yeah, I am not comfortable interpreting the statute to include municipalities or subdivisions. Mr. Bolton's memorandum did a good job of highlighting the fact that the legislature certainly has had no problem in making it clear when government entities are covered under a particular statute. I don't think this is a case of a lesser standard, and and if it is, I don't think it's up to us to change it. I think if this is a real issue, it should be up to the legislature, in my mind, to include municipalities and governmental entities clearly. I base and rest my position on this by looking at the underlying purpose of what we do here and what the law does that we administer, which is public disclosure. And note that the entities that are at issue in this case are clearly under the auspices of and must follow the requirements of the Freedom of Information Act. And so that it may not be the same type of disclosure, but it is certainly public disclosure of information important to the conduct of public business. And it looks like information was provided under that statute in this case, although not what we're looking at specifically here. So I would be inclined to support the motion to not take further action.
Thank you, Commissioner.
I'll be surprisingly succinct. First thing I'll say is I completely agree with my fellow commissioners' comments. And the second thing I'll say is I think it's inappropriate to try to apply the standards around something like a ballot question committee to a public body, including a school board or a town council or a board of selectmen. I think the purposes are different. And even though all of the specific citations may line up in ways presented by both sides, I think there's a fundamental difference. And I'll be supporting the motion.
Terrific. And as I said last time, I found the ads to be more informational than engaging in advocacy. And so I don't need to reach the question of whether a municipality is included in the definition of person. So but I support the motion on the table. Is there further discussion? No. Okay, I'll call for a vote. Commissioner Leclerc?
A yes vote would be to not continue with an investigation. Is that correct?
Yeah, let me restate the motion. The motion is to take no further action on the complaint.
My vote is yes.
Commissioner Marvel? Yes. Commissioner Hastings?
Yes.
And I'll vote yes as well. And I want to thank everybody for coming in. I want to thank everybody for the detailed and really helpful briefing. It was really it's an important question, and it's one that it was a privilege to be a part of answering. Great. So thank you very much.
Thank
And
you.
And we'll move on to agenda item 3, which is the proposed investigation of potential coordinated spending. And Commissioner Leclerc, did you want to?
Yeah, as I'm going to be recusing myself. This is an Aroostook County issue, and I'm going to make the decision to recuse myself from this. So I don't know how that actually works. Do I stay on the line?
No, you just told me that you're recusing yourself, and I will respect that.
Okay, thank you.
Mr. Wayne.
So this is a proposal by the staff to conduct an investigation into something we learned about on our own in the course of helping the Aroostook County Democratic Committee file its reports for 2024, and those reports were late, by the way, and they paid the preliminary penalty for that. But they disclosed as part of that they had paid a local radio station, Channel X, to sort of rebroadcast some paid recorded messages that 6 of their Democratic nominees in that area had already made. Or actually, I don't want to say I know the timing of it, but the candidates paid the radio station to broadcast these candidate messages. And then what we believe happened is that the local county Democratic Committee paid additional amounts to sort of rebroadcast them. For each candidate, there was 3 rebroadcasts during the day, and we saw the invoice from the radio station and also a printout of the different times in which these rebroadcasts occurred. So under the way contribution is defined, if there's a person other than the candidate that finances sort of a republication of a candidate campaign material, including broadcast material, that's a contribution to that candidate. And also if a candidate coordinates or cooperates with third-party spending in general to help promote that candidate, that's also a contribution. So what we would like to do is gather further information, talk to the candidates, figure out if there were contribution, if this all amounted to a contribution to the 6 candidates, talk to the candidates, find out if, did they understand that this was a contribution? Maybe this was inadvertent. But we'd like to, find out what the facts are, and maybe it would be appropriate to have a finding of violation to underscore this part of the law, that there are these alternative ways that third-party spending can result in a contribution. So we'd like to move forward with that if you would authorize it.
Sure, thank you. And I'll move that we authorize the staff to conduct an investigation of this.
Second.
Is there discussion? Yeah, please.
Just a question, Jonathan. How did you find out that soon enough that you were able to contact the Aroostook County Democrats on election day prior to that, I guess before the ads were run?
So if you remember, Ms. Jeanette Rivard had filed a complaint regarding some Republican spending by the state Republican Party on similar advertising with the same radio station.
And we dealt with it.
And you dealt with it at a Zoom meeting the day before the election.
And they withdrew the ads.
And so on the Republican side, they withdrew the ads. And in the course of a conversation that I had with their attorney, the Republican attorney, Josh Tardy, he said to me, look, this is probably going to happen on the Democratic side too. Why don't you try to, we're we're disarming unilaterally on our side. So if you want to avoid a contribution, maybe you should talk to the Democrats. So the day before the election was an extremely busy day, and I wasn't able to make that happen. But I did try to reach out on the morning of the election. But I think that the ads still occurred anyway, so.
Is there more discussion? Okay, I'll call for a vote. Commissioner Marble?
Yes.
Commissioner Hastings?
Yes.
I'll vote yes as well. And thank you, Mr. Wayne. Moving on to agenda item 4, the update on the working group.
I was surprised at my good fortune of being asked to convene this group based on how nice the group was. And it was fun to get a little bit of simple recommendations for a better process to bring as a recommendation to the commission. I want to cite the folks who worked on this. There were 3 meetings and multiple phone calls. Rather than going through a list of name by name, I think you know who they are. You can find out. But the one thing I do want to cite is there were 2 times I can remember clearly where different people for different reasons had a moment of conscience and really wanted to push for something and said, no, you know, for the good of this collective work, I'll back off and support the motion. So I'll let Mr. Wayne get into accurate details again of what we recommended, but in essence, the goal was to simplify and get a little more realistic about monetary amounts, given decades had gone by with those not being revisited. So actually, thank you for the charge. I appreciated it.
Well, thank you for taking the
Thank
responsibility.
you, Commissioner.
Yeah. Mr. Wayne, would you like to,
Yeah, well, I'm happy to describe what the proposal is from this working group. So it has to do with 2 different reporting requirements that are often, they can sometimes be confusing, and the proposal to form this working group came from attorney Josh Tardy, who said, look, these are very complicated and they're burdensome, and maybe there's a way to make it simpler. And so that was the spirit in which the working group approached its work. So one of the 2 reporting requirements is the 24-hour reporting requirement that applies in the last 13 days before the election. And so if our regular filers, who are the candidates and the PACs, the ballot question committees and the party committees, if they receive some larger contributions or make larger expenditures in those last 13 days, they're required to file a report within 24 hours. And the working group thought through this requirement and decided that it made more sense to give these filers a little more breathing room to file these reports, especially considering how busy they all are in the last 13 days with campaigning and everything. So the proposal would be to change the deadline from filing the report within 24 hours to filing the report within 48 hours. And I have to say that actually was the state of the law until the mid-2000s, when there was a decision made because of making the electronic program that no longer is relevant, but to sort of speed up this process. So that's the first proposal. The second proposal is that what's considered to be a larger contribution or a larger expenditure is if the transactions exceed either $1,000 or $5,000. And those thresholds haven't changed in decades and decades. So the working group would like to propose that the sort of accelerated reporting be restricted to even larger transactions, depending on the office of the candidate. It might be $2,000 or it might be $5,000. And PACs and ballot question committees, if they were making an expenditure of $2,500 or more, that would have to be reported. So I won't go through all of them, but basically what would be considered a larger contribution or expenditure that would require a 24-hour report would be higher.
the threshold?
The threshold would be higher. Yeah. Then the other requirement that's at issue here is the independent expenditure reporting. And this is a requirement that relates to when a PAC or a party usually are spending money on some kind of paid communication to the voters, like sending a mailing or paying for an ad. And under the current law, if they spend more than $250 per candidate on one of these paid mailings, they have to file an independent expenditure report. And if it's within the last 2 months before the election, it's very quick reporting. It's within 1 day, 1 calendar day or 2 calendar days. So the working group's proposal is to increase the spending threshold to require an independent expenditure report from spending $250 per candidate to spending $1,000 per candidate. And then the other proposal would be that these reports would be due within 48 hours of the expenditure. So the idea is that it would be sort of on the same time period as the 48-hour reports. And we wouldn't have different deadlines, that, like I said, 1 day deadlines instead of 2 day deadlines, and they would coincide, which would hopefully make them easier for everyone. So that's the proposal. There was a little bit of disagreement that on one of the details, which I note in the memo. But the people who have different views on this all agreed that this could all be presented to the BLA committee if this commission approves, and then the BLA committee could work out those details.
Mhm.
Yeah.
It's like that. Nope. Okay. So these would require legislation to.
Yes.
Okay.
Yeah. And so if this commission is comfortable with the working group's proposal, we would, and you signal that to us, we would draft it up as legislation and probably show that to you at a future meeting if you'd like, and then it could be submitted in time for next year's session.
I think that makes sense.
Makes sense to me. I'm comfortable with it.
Yeah. Commissioner Leclerc?
I'm fine with it. And I thank Dennis and the group for its work.
I agree. I join you in thanking them. Terrific. So I think the consensus is that we'd like you to go ahead and put this together in a proposal.
Okay, will do.
Great. Thank you. All right, moving on to agenda item 5. This is the proposed rulemaking. There's 2 ways we could go about this. Well, let's ask Mr. Wade to kind of brief us first.
Well, this is a rulemaking that the staff is proposing. I guess I would say broadly speaking, there are, as our procedures have developed in terms of how we provide notices of meetings to the affected parties and to the commissioners, those have changed over time, and we found that our rules don't quite reflect what our current practice is, and so we'd like to amend the rules to conform to what makes sense now.
That's a good thing.
Rather than being
Always good.
out of that. And then
To be very clear, you're not suggesting to the public who may be listening that the pattern you wish to follow is to break a rule and then change the rule so it's not broken.
that's not what we're
Okay.
doing. And then there have been some statutory changes relating to contribution limits that are given to candidates who are not enrolled in a political party. Also contributions by lobbyists, their clients and their law firms or consulting firms. And then also the introduction of a new defined term, public communication. So we're proposing changes to the rules to reflect those statutory changes as well. And we can go into these in however much detail the commission would like. The step we're proposing today is that we would be agreeing to initiate a rulemaking, which means we would be inviting public comment. The staff proposal would be to hold a public hearing at your next scheduled meeting at the end of September. And then at a later time, you would consider whether to adopt any of these rule changes.
Excellent. Any questions from commissioners? Yes, please.
Just a comment, as someone who ran for office as an independent, I think it would be easy to make cases either way about the increased clean election support for independent candidates. And I'm not citing this specifically because I don't remember, but in essence, the rationale was party candidates had to go through a primary and then the general, and independents didn't. I think the only offset in my mind, based on experience, is that it frequently may be the case where a party or an enrolled candidate has other means of structural support in a campaign that an independent may not. But I would expect there could be some pushback on that change, although it's one I agree with.
Other commissioners' comments, Commissioner Hastings?
Yes, Dwayne, reading your summary, I understand that you propose all of these to be routine technical rules that would not require legislative approval if adopted, including the campaign limits on increasing contributions to unenrolled candidates.
Yeah, and I might want your counsel to give a better description of this, but it's not that it's our proposal, it's that the way I think of it as an agency manager is the default is that rules are routine technical, meaning the agency has the authority to change them on its own unless they're designated as major substantive, in which case they have to go to the
Who
legislature.
designates them?
The legislature does, so it's actually, there's a requirement in statute that, you know, for any law enacted after 1996, the legislature is supposed to say, when it gives rulemaking authority to an agency, whether the rulemaking authority is
Oh.
routine, technical, or maybe substantive. So, and as far as I'm aware, all of the Ethics Commission statutes have that designation in them. And I believe there is one area where there's major substantive having to do with legislative ethics. And I think everything else is routine tech, or almost everything else is routine technical. That's just off the top of my head. I could be wrong about that, but
You won't ask for a memo.
yeah. But I know we did have to do major substantive, I think, in the last go around because we were making a change to the hearing procedures that applied to legislators in legislative ethics proceedings. And so I think we had to do major substantive there, but otherwise it's routine technical.
If you can add a week to his life, he'll produce a memo. Other comments, questions from commissioners? Terrific. Thank you very much, both of you. So I think there's two ways to proceed with this. I've read through all these proposed rules and that I would be willing to put all of them forward. If anybody has an objection to one or more of them, we can take them one by one, but I think if nobody has any objections to any of them, no, we can do them as a block.
Please do so on my account.
Commissioner Leclerc, is that okay?
Yes, that's fine. Thank you.
Okay, so I'll move that we proceed with rulemaking for the proposed rules that are listed in agenda item 5. And that we solicit public comment. Is there a second?
Second.
Any discussion? Okay, Commissioner Leclerc,
Yes.
Commissioner Martin,
Yes.
Commissioner Hastings,
Yes.
and I'll vote yes as well. And thank you for preparing these and offering them to us. Agenda item 6 is a report of campaign finance constitutional amendments. This is a requirement that was instituted in legislation a couple of years ago that we've been doing every year since. Mr. Wayne?
Right, well, this would be the second annual report of the commission on proposals in the US Congress to amend the US Constitution to allow for greater campaign finance regulation. And so the commission staff did two things. We did some research on the US Congress's website about what resolutions might be covered. And we found two of them. One of them from this year was introduced by US Senator G. and the other one was by Representative Premia Jayapal. And so those are copied in the appendix. And then we also, we noted which of these were jointly sponsored by members of Maine's congressional delegation. Only one was by Senator King. That's noted on a chart on page 2. Then the other action we took was to invite comments from the public, and we actually received 61 comments on the issue of amending the US Constitution for this purpose, and they're all included in the appendix. 7 of those 61 comments were from organizations, but the rest were regular people who wanted to express their point of view on this. So those are all in the appendix as well.
Terrific. Thank you. And I think this is very well done. What do we want to do? Do we want to move to submit this? Is that?
Yeah, that's what I would think would be appropriate. or signal your support. I think a vote would be good.
Yeah, yes.
Okay, yeah.
Okay, I'll move that we submit this to whomever we need to submit it. Who are we submitting it to?
Well,
When aren't we really publishing it?
we are publishing it. Yeah,
Okay.
I think that would be more
Our-
the, yeah. Yeah.
All right.
Thank you, John. That's correct.
We're approving its publication. It's,
Yes.
Yeah.
That's the more elegant way to do it. I move, I'll withdraw my previous motion. I'll move that we approve the publication of this report.
Second,
Is there discussion?
just two quick comments. I appreciate how this was assembled and the work that went into it. I want to thank, the people who did take the time to comment and respond, and note that it really, I didn't count them, but the towns covering the state of Maine, the whole depth of the state is represented in those comments. And that was noteworthy to me.
Thank you. Other comments by commissioners? Okay, we'll take a vote. Commissioner Leclerc,
yes,
Commissioner Marble.
Yes.
Commissioner Hastings.
Yes.
And I'll vote yes as well. Now we have an opportunity, if we wish, to discuss litigation with Mr. Bolton in executive session. Does anybody care to do that? I mean, honestly, I have no need to. I've read the decisions. And I think I'm pretty well up to date.
Yeah,
Is there anything
I
that-
have no specific questions for you at this point,
Or any additional information?
or any additional information, but I'd be happy to answer questions in executive session if anybody would like.
Would you like?
Well, you can tell me if it needs executive session procedurally, where are we now? Is that required?
No, I
No,
don't,
I
I
don't
can
think
do
so.
that, I can tell you that publicly, that's all in the court's docket, so. In the litigation on foreign, the ban on foreign government influenced entities, spending money in elections. That was on appeal to the First Circuit, on a granting of a preliminary injunction preventing the commission from enforcing the law. And the First Circuit ruled last 2 weeks ago, I think, that preliminary injunction was proper, or that the district court didn't abuse her discretion in granting that preliminary injunction. So that case is case is now going to go back to the district court, and we'll move forward with the case with the injunction in place. So the commission, the upshot is the commission is not allowed to enforce the law while the case remains ongoing. The other case is the newer voter initiative on placing limits on contributions to political action committees that make independent expenditures. In that case, the decision was issued last Tuesday, and that was on the merits of the case. That was not a preliminary injunction. So that case is now completed in the district court, and the commission is permanently enjoined from enforcing that law in its entirety. There is a 30-day period where we can potentially file a notice of appeal. So that has not happened yet.
Very good. Thank you very much. Appreciate it. Other questions, comments from commissioners?
yes, these are complex issues, I think, for the public to grasp, in many ways. And I'm wondering if the commission staff issuing some sort of a press release to accurately inform procedurally what's going on and what it means for what we can and can't do as the Ethics Commission. I mean, out on the in the public, you often hear, why can't they do this? Why can't they do that? Why aren't they doing this? Why aren't they doing that? And I'm wondering if it might be helpful to just very factually issue some sort of release as to what this means for the work that the commission does.
That
Just-
might make sense for the one that has been finalized. particularly if it isn't appealed by the Attorney General. What do you think, Mr. Bolton?
I think that'd be fine. I think it would be fine for, really for either of them. You know, I think with the one where it's just a preliminary injunction, you know, making clear that the status could change in the future and that it's, you know, it's a temporary, at this point, at least, you know, a freeze on the law. But I'd obviously want to take a close look at whatever we put out.
Sure.
But I don't have any issue with, you know, providing guidance to the regulated community about what their obligations are while these, you know, these matters are ongoing.
Mhm.
Yeah, I mean, my thought is that, you know, to put out an accurate statement, rather than let it be interpreted, would be a good idea, especially in light of, I mean, one of these referenda was the most popular referenda item ever voted on in the state of Maine, I think. So I think it's important for people to understand that it's not just how the decision is being made, that's being made by the courts, and what the process is. So I think that would best be stated by the commission with Mr. Bolton's assistance or however. I just would like accurate information out there.
Yeah, I think that's a very nice idea, and I think it fits perfectly with our public education function.
Great.
So, are we agreed that maybe we can ask Mr. Wayne to draft something up and together with Mr. Bolton, and maybe we can approve it at the next meeting? Or even, I
don't think we need.
I actually,
I
think we don't need to approve it. I think we'll we'll lean on your expertise to.
Right.
And then if we don't like it, we can let you drift in the wind.
Yeah.
See, if I was a political person, I would have figured that out a while ago. So if you could do that,
Please.
we'd appreciate it. That would be nice.
Great idea.
And it's a nice thing, I think, to do for the public.
Yeah, thank you.
Yeah, thank you for bringing it up. Is there any further business to come before the commission?
Just to confirm, there's no meeting in August.
Correct.
So, okay, so we do have a September meeting now scheduled, don't we?
Yeah.
Is it scheduled?
On the 24th?
It is.
Is that right?
It is scheduled for September 24th.
Let me make sure I've got it in there.
Well, we haven't gone beyond that. That's the only scheduled meeting we have at this point, isn't it?
That's correct.
Oh, I didn't have it in there.
Well, I don't know what we would have done with that.
Oh, that reminds me. Would it be out of order to discuss the possibility of random drawings out of a hat to assign 2 votes to one of the 4 of us every time to preclude a tie vote on a serious matter? Kidding.
Doesn't sound, I don't see any legal problems. I'm kidding.
So,
All right, well, go ahead.
well, go ahead.
No, please.
I move we adjourn. What's that?
Outstanding.
Second,
That being not debatable, I'll call for a vote. Commissioner Leclerc,
Yes.
Commissioner Marvel?
Yes.
Commissioner Hastings?
Yes.
And I'll vote yes as well. We stand adjourned. Thank you very much, everybody.
So I was gonna
Thank you.